The Supreme Court on Monday, January 22, observed that it would be impermissible under the law for a judicial magistrate to take cognizance of a supplementary charge sheet submitted after further investigation if it doesn't contain any fresh oral or documentary evidence, would be impermissible under the law. Reversing the concurring findings of the High Court and Trial Court, the bench of Justices Surya Kant and K.V. Vishwanathan noted that while submitting the supplementary charge sheet as a result of an order of further investigation under Section 178(8) of the Code of Criminal Procedure, the investigating officer shall mention new evidence found to substantiate the conclusions drawn by him. Otherwise, such supplementary charge sheet lacks investigative rigor and fails to satisfy the requisites of Section 173(8)(c). The provision for submitting a supplementary report infers that fresh oral or documentary evidence should be obtained rather than re-evaluating or reassessing the material already collected and considered by the investigating agency while submitting the initial police report, known as the charge sheet under Section 173(2) Sub-PC.R. Briefly put, the appellant's accused filed an application seeking discharge before the trial court in a pending criminal case, but the application turned down by the trial court. In the meanwhile, the trial court directed further investigation on the application of the complainant and resultantly allowed the police to submit the supplementary charge sheet, thereby adding charges under Sections 468, forgery for the purpose of cheating, 471, using as genuine a forged document, and 201 causing disappearance of evidence of offense, or giving false information to screen offender, of IPC and Section 12B of the Passports Act, 1967 against the appellant's accused. The appellant's application seeking discharge was turned by the trial court. Moreover, the High Court also dismissed the revision application of the appellant seeking revision of a trial court's order of not discharging the appellants. It is against the said impugned order of the High Court, the appellant's accused preferred a criminal appeal before the Supreme Court. Issue. The question appears before the court whether the framing of charges against the appellant accused persons on the basis of the supplementary charge sheet, submitted pursuant to the completion of the further investigation, is sustainable under law. Observation. The court stated that the investigating officer can submit the supplementary charge sheet only when further evidence, whether oral or documentary, is obtained by the I.O. In the present case, the supplementary charge sheet relies upon the same lab report to frame charges against the accused as was relied upon by the I.O. while submitting an earlier charge sheet. The court find no new evidences in the supplementary charge sheet while observing as follows. Instead, the supplementary charge sheet relies upon the Truth Lab report dated the 15th of July 2013, obtained by respondent number 2, which was already available when the original charge sheet was filed. The term further investigation stipulated in Section 173(8) Sub-PC obligates the officer in charge of the concerned police station to obtain further evidence, oral or documentary, and only then forward a supplementary report regarding such evidence, in the prescribed form. The court noted that the order by the trial court permitting further investigation on the application of the complainant resulted into a mechanical investigation by the I.O. without applying the mandate of Sec. 173(8) Sed.P.C. In the absence of any new evidence found to substantiate the conclusions drawn by the investigating officer in the supplementary report, a judicial magistrate is not compelled to take cognizance, as such a report lacks investigative rigor and fails to satisfy the requisites of Section 173(8) Sed.P.C. What becomes apparent from the facts on record of this case is that the investigating agency acted mechanically, in purported compliance with the trial magistrate's order dated 24.06.2015. The court expressed dissatisfaction towards the approach of the trial court while framing the charges against the accused on the basis of the supplementary charge sheet. It is worthwhile to mention that the supplementary charge sheet majorly relied the private laboratory report, which according to court couldn't be safely relied unless corroborated by compelling evidences. As observed earlier, the state FSL report does not substantiate these allegations. In our opinion, a paid report obtained from a private laboratory seems to be a frail, unreliable, unsafe, untrustworthy and imprudent form of evidence, unless supported by some other corroborative proof. It is painful to mention that respondent number 2 has not produced any other substantive proof, nor has the investigating agency obtained any such material in compliance with the trial magistrate's order for further investigation. The basis on which the trial magistrate formed a prima facie opinion, in the absence of such supporting evidence, is, therefore, beyond our comprehension. Thus, the court allowed the criminal appeal preferred by the appellant accused persons, while setting aside the impugned order of the High Court and the order of the trial court directing further investigation. Case details. Mariam Fasihuddin and Dar versus State Bayat Agori Police Station and Dar. Criminal Appeal Number 335/2024, arising out of Special Leave to Appeal, CRL, Number 2877/2021.